Hey folks, Dale Davidson here, Davidson Law Offices. Thank you for tuning in today. Hey, so today we're going to be talking a little bit more about estate planning versus VA benefits. And look, everybody has an estate, okay? Whether you think you do or not. Estate planning is not just for the rich and famous, okay? If you've got a house, you got a car, you got a bank account, whatever it may be, you have an estate that you need to plan for if, God forbid, something happens to you prematurely. So let's talk about the basics of an estate plan. And the basics of an estate plan, of course, is a durable power of attorney, advance directive, and then a last will and testament. I've covered the durable power of attorney and advance directives in a previous video, so I'm just going to really talk about last will and testaments today. Exactly what is that? And should you use a last will and testament, or you need a trust? What's the difference between those two? And we're going to talk a little bit about that. So a will is basically your direction put on paper, signed and executed in accordance with whatever your state law is. And it says, when I die, this is who's going to get my stuff. This is who's going to be in charge. And the people who are getting my stuff, this is how they're going to get it. Maybe they get it in trust, or maybe they get it outright, whatever it is. But that is your direction to the world that says, when I die, this is what happens to all my stuff. All right? Just because you're married, okay, doesn't mean that your spouse is going to get everything unless you have it in writing. So if you don't have a will and you think your spouse is going to get everything, wrong answer. It's just not going to happen. I know here under Georgia that if you're married and you have children, let's say you have 2 children, that you don't have a will, your spouse gets 1/3, your children get 2/3 of your estate. What happens if your children are minors? Okay. Could be a mess. So a will is a very simple document to do. You just got to have it in writing. Again, it's got to be executed in accordance with the statute, 2 witnesses and a notary, okay? And again, that's what you want to happen. We don't want the state and the government telling us what we're going to do with our property when we die. So then a lot of people come see us and says, well, I don't think I need a will, but I think I want a trust. My reaction is why? Okay, because we use trust in certain ways. Okay, and there are different types of trust. Okay, there's the revocable trust, which says that it's a trust that says during my lifetime I'm in 100% control of everything. Okay, let me show you an example of a trust. Okay, yep, y'all have seen this before. This is my trusty handy dandy trust bucket. So this is a trust, and I don't have a top on it. This is a revocable trust. I have my property and my stocks and bonds, and I have my cash. Whatever I have, I put in here. Now, I can take things out and put things in. This is mine. Nobody can tell me what to do with my stuff that's in my trust. All right? But when I die, we put a top on it, becomes irrevocable, meaning nobody can change it. This is whatever the terms of this trust are, they are as far as distributing my property out. So a trust is either revocable. We use those during lifetime. Those types of trust, and by the way, all trusts avoid probate. A will, you would have to probate. But a trust avoids probate. If somebody becomes incapacitated during their lifetime and you have a trust, then that successor trustee steps into their shoes and continues to manage that property in accordance with the terms of the trust for the sole benefit of the person who created the trust. Okay? Now, in the situation of a last will and testament, if you become incapacitated, then you'd have to rely on your durable power of attorney to step in to manage the individual's property. And banks have a little they have a little heartburn over durable powers of attorney sometimes, so just be careful. So the trust we use during lifetime, like the revocable trust. We also have irrevocable trust during lifetime for certain things, like asset protection. But we can also put a trust inside a will. That's called a testamentary trust, meaning if you have a trust in your will that says, when I pass, all my stuff goes into trust for the benefit of my spouse, and my spouse will receive income for his or her lifetime and can get principal for health, maintenance, and support. Okay? That's a typical trust. Or if you have a spouse who has supplemental needs or a child who has supplemental needs, and you don't want to impact their benefits that they're receiving, such they may be on Medicaid, okay, or some kind of disability. You don't want to disrupt those. So you would use that type of supplemental trust to avoid those things. So you've got the testamentary trust, or the trust that's outside the will. We call those inter vivos trust or during lifetime trust. Lifetime trust include revocable trust or irrevocable trust. Now, the difference between a revocable trust and an irrevocable trust is quite simple. Once you create and fund the irrevocable trust, you're not supposed to be able to change the disposition of everything in that irrevocable trust. Okay, there are ways around that, though. Okay, there always is. So, as a general rule, you can't change an irrevocable trust. And we use those a lot of times for asset protection planning, to protect assets from potential future creditors, nursing homes, things of that nature. So, again, just to kind of recap everything, we have a will, which is a necessary thing. Everybody should have a will, because we don't want the government to tell you who's going to get your property and how they're going to get it and when they're going to get it. We want you to be in charge, to say, this is who's going to get everything and why and when. As part of that, you can have a trust or not have a trust. It's up to you. If you are, for instance, a Florida resident where probate is a paper tiger, you may want to consider having a revocable trust during your lifetime that says that I own everything and I control everything, but upon my death, it becomes irrevocable, but it's not subject to probate. Because remember, all trusts are not subject to probate. And that can be a big cost savings and a big time savings when you're probating. Here in Georgia, we have self-administering estates, so the probate is not that bad. So a lot of times in Florida, what we'll do is we'll do the revocable trust in order to avoid probate altogether, because it is a burdensome proposition. So, hey folks, check out this estate planning video we just did a couple of weeks ago. It's going to give you a little bit more in depth as to the basics of estate planning. Until next time, you be blessed.